This meeting is now being recorded.
Good afternoon and welcome to the Public Defense Commission webinar on standards for defending attorneys. My name is Kimberly Simmons. I'm the Executive Director of the Commission, and I appreciate having your attendance today. Today, this is our roadmap. I'll talk very briefly about the Commission, the powers and duties, and who we are. I went through that extensively in the webinar yesterday, so I won't go through that as extensively today. I'll also talk to you just briefly about administrative rules, which rules are currently in effect, where you can find them, and again, I'll briefly touch on those as I went through them in a bit more detail in yesterday's webinar. Today, the proposed rules that we're going to be talking about, as well as the current rules, will be IDAPA 610107, rules governing standards for defending attorneys, and then IDAPA 610108. I went through that extensively in yesterday's webinar, but we are touching on that today because that will be the chapter that includes the document standards for defending attorneys, which I will go through today, both the current and proposed versions. The Public Defense Commission gets its authority and duties from the Idaho Public Defense Act. Idaho Code 19850, subsection 1, subsection A, lists out 7 different areas in which we are mandated to create rules. Idaho Code 19851B through E are also mandates from the legislature that include making recommendations to the legislature regarding public defense. They specifically mention enforcement mechanisms and funding issues. Those recommendations are to be made to the legislature each year by January 20th. We're also mandated to review defending attorneys in Idaho for compliance. Idaho Code 19850 subsection 2 are things that the Commission may do. We may establish procedures for extraordinary litigation costs and handing out funds for extraordinary litigation costs. We may hire an executive director and other personnel, things like that. As I mentioned, I went through all of these sections in a bit more detail in the webinar from yesterday. That webinar will be uploaded to our website at the web page that you see on your screen. I attempted to upload it yesterday and this morning, but the state is having some statewide issues with internet, and we cannot edit our website. As soon as that is fixed, I will upload that webinar, and then I will also upload today's webinar. Today, we're specifically talking about Idaho Code 19850 1A little VII, standards for defending attorneys that are based upon Idaho's principles of a public defense delivery system. Those 10 principles that are listed in the statute are also part of the current rule, and they're based off of the ABA guidelines. The Commission consists of 7 members. As you can see, we have a member from Juvenile Justice Commission, the State Appellate Public Defender, representatives from the counties, as well as the defending attorney representatives. Those 4 members are appointed by the governor. Then we have a representative from the Supreme Court, and then 2 representatives from the legislature, 1 from each house. The staff consists of myself as the executive director, Kelly Jennings, our deputy director, who's been with us since last August, so August of 2016, Nicole Danny, who's been with us since 2014, and then our 3 regional coordinators who are new, and they are, one is located here in Boise, which is Brian McCoy, Aaron Freudenthal, who's located up in Moscow, and then Jared Ricks, who's located out in Blackfoot. Public Defense Commission administrative rules. Rules are something that are enforced under law. They come underneath statutes, and statutes come underneath the Constitution in terms of priority and a hierarchy. Our current rules, or the actual term would be final rule, are ones that are in full force and effect. And under our statute, any current rule or final rule that's in effect by May 1 of a given year must be complied with by March 31st of the following year. There are 4 other types of rules. There are rules that are under negotiation, there are proposed rules, and then I'm going to skip temporary rules, but pending rules. So negotiation, proposed rules, and pending rules are rules that are being formed in the rulemaking process that do not have any force and effect of law. Temporary rules are rules that do not go through a negotiation process but are fully in force and effective when they are adopted by an agency. Again, for more information on the definition of those rules, you may view our webinar from yesterday, or you may go to the rules website. Where can you find the rules? Find the rules on our website. I'm going to pull that up for you right now so that I can help you navigate. Give me one moment here, and I will share that screen with you. Or not. Sorry about that. Okay. So here's what our website looks like. Currently, we do have, since we are sort of in rulemaking season, if you will, we have the rules mentioned on the front page. Throughout the year, you can go to the rules and standards portion on the left side of our website, and you'll see that there are rules, standards, that's what would be current, and you'll see proposed and pending rules, and then you'll see rules, negotiated rulemaking, which are rules that are in the negotiation process. Okay. Another location to find our rules would be on the rules website. The belongs to the Administrative Office of the Rule Coordinator. The current rules for every agency are on that website. You click on that and then find our agency, or if you go to that website and find the Public Defense Commission, you'll find that we have 3 chapters that are currently in effect. And these are the rules that we have in effect that are yet to be created and that are being proposed at the current time. So in effect, we have rules governing the administration of training funds, allocation for defending attorneys. That is a rule that talks about how we use funds to put on trainings for defending attorneys throughout Idaho, as well as provide scholarships to defending attorneys to attend trainings outside of Idaho, or even within Idaho that are not hosted by the Public Defense Commission. 610104 is a temporary rule that went into effect in March. That's a rule governing procedures and forms for the application and disbursement of indigent defense grants. It simply addresses the procedures that counties must use to apply for grants and the procedures that the Commission will use to review the grant applications and to disperse those grants. Based off of our statutory language, and there's nothing really surprising in that rule. And the reason why we did a temporary rule was so that if counties wanted to appeal a decision we made on a grant application this year, they could. If there was no rule in place, we do have the authority to establish temporary procedures, but if there was no rule in place, then there was no way for counties to appeal on a decision that the Commission made. And then 610107, rules governing the standards for defending attorneys. There is a current rule in effect, and I will be going through that here in just a moment. And then proposed rules right now are 610106, rules governing procedures for oversight, implementation, enforcement, and modification of standards. That will be that was gone over in depth in the webinar from yesterday. 610107 also has a version of a proposed rule. I will be going through that with you today. And then 610108 is not technically proposed yet. It's currently in negotiation. I will be submitting it on Friday to the Rules Office. It should be published as a proposed rule on November 1st. And we'll briefly go over that today, but I did go over that in depth yesterday in yesterday's webinar. There are 3 chapters which we have not created yet, and we are mandated under the statute to create rules in those areas, and that's 610102, 610103, and 610105. You can see that those deal with uniform data collection, with contracts, and administrative rules. Those will be things that we have to create in terms of rules, and we'll do so as we go forward, just not this year. Okay. So let's talk about the standards for defending attorneys that are currently in place. Again, the authority to create this rule is in 19851A little VII. It is published as IDAPA 610107. It was effective May 1st. Compliance has to come by March 31st of 2018. There is the rule, and in the rule, there are definitions, there are documents incorporated by reference, and then we also define public defense roster. And I'm going to go through those definitions very briefly in just a moment, as well as the documents that are incorporated by reference, which would include the Idaho's Principles of an Indigent Defense Delivery System that were modeled substantially after the ABA guidelines, but they were tailored for Idaho. And then I'll go through the standards for defending attorneys that's currently in place. The Rule 610107 includes definitions of case, caseload, defending attorney, established standards, fiscal year, indigent defense provider, and workload. The case definition was negotiated last year. I went over that briefly in yesterday's webinar. And this definition will no longer be in this rule, but will be moved to the Chapter 610108. So when we go over the proposed rule, you'll see this definition as well as the others deleted, but that doesn't mean they're going away. That just means they're moving. The case definition does not match what the Supreme Court has defined as a case, and we recognize and understand this could be a problem. I will inform you that we are collaborating with the Supreme Court to try and find a way to match the definitions. And I was informed the screen is blank, and I'm going to put the PowerPoint back on the screen. I apologize for that. There we go. All right. Not a lot of information on there. The rule also talks about the public defense roster. This is a roster of all institutional defender attorneys and defending attorneys that provide public defense in Idaho. It's going to be updated throughout the year, and it's available upon request from our office. If a defending attorney is not on a roster but would like to be included on the roster, they can apply and contact our office for an application. The rule rounds out by saying in a section called Application of Established Standards. It refers to the standards in the incorporated document Standards for Defending Attorneys. They apply to all indigent defense providers, defending attorneys, members of the public defense roster, and any attorney who is assigned to represent at least one indigent defendant or is otherwise assigned to represent an adult or juvenile at public expense in state courts in a fiscal year. In this rule, we define fiscal year as the county fiscal year, which begins on October 1st and ends on September 30th. So the effect of that portion of the rule means that if an attorney handles an indigent defense case or represents an adult or juvenile at public expense within a county fiscal year, then the standards that we create apply to them for that fiscal year, meaning the attorney must comply with those. The standards for defending attorneys, the document that is incorporated by reference, also includes the 10 Idaho Principles of an Indigent Defense Delivery System. And I will go through and highlight the important parts of that rule so you know what is currently in effect. All right, you should now see the current version of Standards for Defending Attorneys, last updated in November. If you need to see that bigger, I believe you can increase that to 100%. At the top of your screen, you'll see a button that says Fit to Screen. And if you click 100%, that will make that a little bit bigger for you so you can see the document itself. The text in blue are the Idaho's principles of an indigent defense delivery system. They're taken straight out of the statute. The text underneath the text in blue, so for instance under Roman numeral 3, you'll see some text there regarding workloads. That is the language that was promulgated last year and is currently in place. So the current standards state that defending attorneys' workloads should permit effective representation. In sum, attorneys should not handle more cases than they can handle effectively and meet constitutional obligations. Under Section 5, defending attorneys' abilities, training, and experience should match the nature and complexity of the cases in which they provide services. Basically, again, a defending attorney should handle cases with which they are experienced and trained to handle. Specifically, I will scroll down here to Section H. When an attorney handles a case involving a specialized area of law, that's includes but not limited to the following: juvenile cases, child protection cases, termination of parental rights and guardianship cases, civil contempt, mental health commitment cases, immigration law, and cases involving significant mental health and or competency issues. Attorneys shall acquire within the 2 years prior to, or within the last 3 years, acquire 3 hours of continuing legal education in the particular area, the specialized area. If a training course is not available or was not available, then that defending attorney shall consult with a more experienced attorney until such specialized training is available. Under subsection 6, the defending attorney assigned to a particular case should, to the extent reasonably practicable, continuously oversee the representation of that case and personally appear at every substantive court hearing. This standard talks about a defending attorney in what we call vertical representation. So once a defending attorney is assigned, to the extent that it's reasonably practicable, and that same attorney should carry out the case to its completion. Many questions we've received on this standard is, well, what if someone has to cover a court hearing for me? That is totally fine. The intent and purpose of this standard is that the attorney that was assigned to the case be consistent for the client. That attorney be the one that the client talks to about the case, that they're the ones that they work out the strategy, get their legal advice from. If someone has to cover a court case because as defending attorneys, we are very busy and we may have to be in 2 different courtrooms at the same time, it is okay to have someone cover a case. The standard also requires that a defending attorney be available at initial appearances. Subsection 8 talks about continuing legal education hours that are required by defending attorneys, and the standard requires 7 hours related to the representation of indigent defendants or other individuals who are entitled to be represented by an attorney at public expense each year. Basically, almost any continuing legal education course will fit in this category other than water law or something very civil in nature. So those are the standards that are currently in place, and attorneys must comply and counties must comply by March 31st of 2018 or have a plan to come into compliance by using grant funds from the Public Defense Commission. Proposed rule. As I mentioned, the proposed rule eliminates the definitions, because the definitions are moving to Chapter 610108. So the difference between the proposed rule and the current rule is twofold. The documents incorporated by reference are being moved to 610108, as well as the definitions. So you'll see, I'll share this document with you in just a moment, but you'll see that those have been deleted. We have made a few edits to the public defense roster definition and the application, and I will go through those. And we have added capital counsel roster. Capital counsel roster is added simply because in Standards for Defending Attorneys, the proposed version, we'll talk about capital counsel qualifications. And so we will have a roster of attorneys that are qualified to handle capital cases, just as the Supreme Court does now. Standards for Defending Attorneys, as proposed, will now be incorporated specifically into 610108, but 610108 is incorporated by reference into 610107. Hope I have not confused you too much. The standards for defending attorneys that I will go over with you today will become formally proposed in the administrative bulletin. It doesn't get published in the administrative bulletin because it is a document incorporated by reference, but it is available to you now. We will talk about it at the public hearings that are coming up starting next week. And so essentially we're going to treat it as if it were proposed at this time. And that's important so that we can get your comment and feedback on it. 610108, again, that's not officially proposed, but it will be, and we're treating it as if it were proposed at this time. But this is a chapter that consolidates all our definitions and the documents incorporated by reference. And it incorporates the Standards for Defending Attorneys documents, and then this year we're proposing a standard regarding investigators and experts. And these are the three areas addressed in the standard: independent investigation, continuing duty to assess a case, and reasonable access to investigators and experts. Defending attorneys should be regularly reviewed and supervised for compliance. And finally, our capital counsel qualifications and roster standards. All right. I'm actually going to back up to the rule here. If you give me a moment, I will share the rule as proposed with you. Okay, and I'm going to select a different view here, one page. Hopefully that makes it a little, I'm going to make it a little bit bigger. That's too small. Okay, and hopefully you can see that. Now you'll see most of this rule is not changing, especially in the beginning there. But as I mentioned, the incorporation by reference, we take out the documents that were incorporated in the current rule, and we're moving them to 610108. So that is referenced in this rule, so it will still be included in our standards. And then the definitions, again, we're taking them out of this current rule and placing them into 610108. Public defense roster. Because we're adding the capital counsel roster, you'll see that we've added the word public defense roster into the subsections. The difference mainly with the definition of public defense roster for the proposed rule is that we're adding the word compliance. So if you, look at section 01B, the public defense roster contents will include the name of each compliant defending attorney. As I discussed in yesterday's webinar, if a defending attorney is not compliant with standards, they can be removed from the roster. That just means they cannot take advantage of public defense training or scholarships as outlined in IDAPA 610101. And you'll see that there at the bottom where it says membership benefits. So as long as the defending attorney is on the roster and they're compliant, they can take advantage of our trainings and scholarships. And then we added capital counsel roster membership. We'll create and maintain a roster of all qualified capital defending attorneys. We'll maintain that roster. And then we have a section talking about the contents of that roster. And we will be creating an application for capital counsel roster inclusion. So any defending attorney who wishes to represent indigent defendants in a capital crime must apply for inclusion on the roster, just as they do now with the Supreme Court. And just a little background, if you are not aware, the Idaho Supreme Court does maintain the roster of capital counsel who are qualified to handle capital cases. That is in Idaho Criminal Rule 44.3. Those are the qualifications and the way you're supposed to apply. When I talk about our qualifications, I'll talk a little bit about some of the differences between that rule and our standard that we're proposing. But the Supreme Court continues to feel uncomfortable qualifying attorneys to handle capital cases, then reviewing their performance in a post-conviction case, for instance. And so, because it is our authority and duty now to create standards for indigent defense providers and defending attorneys that includes capital cases, they asked for us to go ahead and create this rule this year so that they can get rid of so they don't do it anymore, so they would not maintain the roster anymore, and we would maintain it. And I'm going to briefly now talk about 610108. There we go. That should be shared on your screen now. I'm going to make that a little bit bigger for you. I'm not going to go through this extensively. Please watch yesterday's webinar if you're interested in that, or attend some of our public hearings. But you'll just see here that we've incorporated the Idaho's Principles of an Indigent Defense Delivery System here, the standards for defending attorneys here. We will incorporate the application for capital defense roster, which we have not created yet. That is in a very poor draft form right now. And then we have several definitions within this chapter that will apply to all the chapters that we create. All right. And that's all I'm going to mention about that rule. And if you have questions sort of about how that all works, since we had the standards for defending attorneys in 610107, they're going to move to 610108. I'm happy to answer those either near the end of the presentation today or if you want to just give me a call or shoot me an email, because I know that that can be somewhat confusing. But let's talk about, which I know most of you are very interested in talking about or hearing about today, are the proposed standards for defending attorneys. All right. I'm going to make this a little bit bigger for you. Should have been a little bit more prepared, I suppose. Okay. The first change you'll see there is that we just deleted Section 7. That's just sort of a form, a deletion. It doesn't really mean anything to anyone, but this is the document that will include all of your standards for defending attorneys. And then we added a title here, Performance Standards Utilizing Idaho's Principles of an Indigent Defense Delivery System. And the reason for that addition will become clear here once I get through once I scroll through these 10 principles and the additions that we've made to this proposed rule. We still have not added any text under Principles 1 and 2. We will be doing that in the future. Don't believe that there have been any changes made to Section 3. We've not added any text to Section 4. And I don't think we've made any changes to Section 5 other than subsection 8. This talks about cases that require specialized knowledge. We exclude capital cases from this particular section of the rule because there are different continuing legal education requirements to handle capital cases, and I'll go over that in a moment. But that is why we have added that language with the exclusion of capital cases. We did add subsection I here that just states that a defending attorney shall not be assigned to a capital case unless they have met the qualifications in and is a member of the Capital Counsel qualifications and roster performance standard that we'll go over here in just a moment. In subsection 6, in the section that talks about initial appearance and vertical representation, we add language that a defending attorney has a continuing duty to evaluate a case for defense investigations or expert assistance. And this is in relation to our performance standard that we're proposing for investigations and experts. Decisions to limit investigation must take into account consideration the client's wishes and the client's version of the facts, except in capital cases where constitutional protections require investigation and or mitigation without regard to the client's wishes. For the non-attorneys on the webinar today, there is a distinction for investigation and mitigation in capital cases and investigation and mitigation in non-capital cases, and that is the reason behind that language there. We've added a bit to subsection 7. There should be reasonable equity between defending attorneys and prosecuting attorneys with respect to resources, staff, and facilities. This is the standard that discusses how defending attorneys should have equal access to investigators and experts as a prosecuting attorney does, and that reasonable requests for funds to get an investigator and or an expert must be funded as required by law. We have not added any language to subsection 8, but we have added language to principle number 9. This is in regards to attorneys being reviewed and supervised for compliance. And we really added this language because we created the rule regarding oversight and enforcement, which is in IDAPA 610106. So this standard says that since attorneys should be regularly reviewed and supervised for compliance, the defending attorney shall provide relevant information to a PDC regional coordinator or PDC staff member as requested. Pursuant to Idaho Code 19864, a defending attorney shall submit a completed annual report to the PDC each year by November 1, and that's statutory. PDC regional coordinators shall report to the PDC regarding compliance issues with defending attorneys in their respective regions as described in IDAPA 610106. For more information on the oversight and enforcement, you may watch our webinar from yesterday or attend some of our public hearings coming up next week. This is the part where I was saying there's a reason why we added the performance standard title to the beginning of the principles, because we have additional performance standards that didn't fit neatly into those 10 principles. And so we've added a section called Additional Performance Standards for Defending Attorneys. We are proposing 2 performance standards, and as I talked about, that's in investigation and experts, and then capital counsel qualifications and roster. So the performance standard proposed for investigation and experts talks about attorneys conducting independent investigations, that attorneys shall request funds to retain an investigator to assist with their client's case when it's appropriate, and the defending attorney shall request the assistance of experts where it's reasonably necessary to prepare the defense and rebut the prosecution's case. Fairly standard for a standard regarding investigation and experts. We did sort of model this a little bit off the standard that Michigan created last year and was that is currently in place for that state. Their system is very similar to ours in that their counties run their systems. But we did try to take into account the rural nature of Idaho when creating that standard. All right, let's talk about the capital counsel qualifications and roster. Section A, applicability. So long as the state is legally entitled to seek the death penalty, these standards shall apply. So basically until the state can no longer legally seek a death penalty in a case, and if the case is a capital crime, meaning they could seek it, then the following standards will apply. First, we define the defense team. The defense team shall consist of no fewer than 2 attorneys, qualified in accordance with these standards, must include an investigator and a mitigation specialist. At least one member, so one of those 4 minimum members, must be qualified by training and experience to screen individuals for the presence of mental or psychological disorders or impairments. It does not require one of those members to be trained and have a degree in psychology or social work. It just means that they are qualified to screen them for further evaluation, or if they need further evaluation for the presence of mental or psychological disorders or impairments. Generally, a mitigation specialist should be trained and experienced enough to be able to do that. And so you should have no trouble meeting that requirement. In any case in which the death penalty may be imposed, at the very first court appearance after a crime in which a death notice could be filed as charged, 2 qualified defending attorneys shall be appointed to represent that indigent defendant. 1 counsel shall be designated as lead and the second as co-counsel, and there are different qualifications for each, and we will go through those. As soon as possible after counsel has been assigned, then the lead counsel shall assemble the defense team with the help of co-counsel if that's practicable. The team shall include at least 1 mitigation specialist and 1 fact investigator. Again, 1 member qualified to screen for the presence of mental or psychological disorders or impairments. And all members must provide zealous and effective representation. C talks about the requisite training and skills required to handle capital cases. Defending attorneys shall be familiar with and be trained in all of the following areas. They must understand, know relevant state, federal, and international law and court rules. Excuse me, I'm jumping ahead of myself. So this section talks about the trainings they have to receive, and then the programs that they attend shall address these things. So relevant state law, federal law, international law, and court rules. Pleading and motion practice in capital cases. Pretrial investigation, jury selection. And all of these must be tailored towards defending capital cases. And those are important. And there's several of those sections. These sections are the same sections that are mentioned in the ADA guidelines. 2 talks about how many hours a defending attorney must have in these areas, from these specialized programs, and that is 12 continuing legal education credit hours every 2 years, which equates to 6 CLE hours each year. And it must be a program that has been approved by the Public Defense Commission. Once this rule is created and final, we will provide a list either on our website or readily available to you of the programs that we have found that would be approved by us. If there's one on there that an attorney would like to attend that is not on our approved list, you can send us the information and we can go through the process of approving it. 3 here talks about the non-attorney team members. They shall receive their continuing professional education as appropriate to their areas of expertise. So if you have a licensed social worker as a mitigation specialist, that social worker should be up to date with all of their professional education requirements, if any. So D now talks about the attorney qualifications. So 1, for the trial level, we break this down into lead counsel and co-counsel. Lead counsel assignments shall be made to attorneys who are experienced and active trial practitioners with at least 10 years litigation experience. This is a change from the Supreme Court rule, which I believe is 5 years currently. 2 talks about serving as lead counsel in no fewer than 10 felony jury trials, and that is an increase from the Supreme Court rule that they serve either as lead or co-counsel in one case in which the death penalty might have been imposed and which was tried through to verdict, or served as lead counsel in the sentencing phase of a capital case. They must be familiar with and experienced in the utilization of expert witnesses and evidence, must have attended at least 12 hours of approved capital training within the last 2 years, demonstrate necessary proficiency and commitment which exemplify the quality of representation appropriate to capital cases, have substantial knowledge and understanding of relevant state, federal, and international law, both procedural and substantive, governing capital cases, have skill in the management and conduct of complex negotiations and litigation, have skill in legal research, analysis, and the drafting of litigation documents, have skill in oral advocacy, have skill in the use of expert witnesses and familiarity with the common areas of forensic investigation, including fingerprints, ballistics, forensic pathology, and DNA evidence, have skill in the investigation, preparation, and presentation of evidence bearing upon mental status, have skill in the investigation, preparation, and presentation of mitigating evidence, have skill in the elements of trial advocacy, such as jury selection, cross-examination, opening and closing statements, have skill in jury selection focused on methods that have proven successful in capital cases, such as the Colorado method. Many of these subsections are added to this standard versus the Supreme Court rule, and many of this, if not all of it, is taken from the American Bar Association guidelines. This last section here talks about an attorney being familiar with and agreeing to abide by the performance standards in the current American Bar Association guidelines for the appointment and performance of defense counsel in death penalty cases. Co-counsel. The substantial difference between qualifications for co-counsel and lead counsel is the amount of experience required. So co-counsel must have at least 5 years litigation experience and have served as lead counsel in no fewer than 5 felony jury trials. They also need at least 10 hours of capital training within the last 2 years instead of 12 that's required for lead counsel. These are, again, increases from the current Supreme Court rule. The remaining of these sections mirror the subsections for lead counsel. These are taken again from the ADA guidelines. And this section ends down here with the attorney being familiar with and agreeing to abide by the ADA guidelines. Just as in the Supreme Court rule, there are alternate procedures for getting onto the roster. So attorneys who don't meet each and every qualification in the paragraphs that we just went through, so for lead counsel and co-counsel, they still can apply to be on the capital roster. They must demonstrate familiarity with the American Bar Association guidelines, and they must agree to abide by them. They must have some experience in some stage of death penalty litigation, whether or not a death penalty was imposed. And they must attend, within 1 year of application, a program that is an intense capital training program that the Public Defense Commission has approved. An intense capital training program might be the Death Penalty College that's hosted once a year in Atlanta. I do believe there are a few different intense training programs throughout the U.S. each year. The Public Defense Commission intends on being able to provide scholarship money to attorneys to attend those programs, because I understand that many defending attorneys don't go because they can't afford to go. And so this would be something the Public Defense Commission would intend on paying for. The next section of the standard talks about the qualifications for appellate and post-conviction counsel. Here, lead appellate or post-conviction counsel must qualify just as lead trial counsel Second chair must qualify just as co-counsel for trial, as we've described, or they can meet the following requirements. They must have at least 10 years experience in active post-conviction and appellate cases in criminal defense, must serve as court-appointed or retained counsel in the appeal or post-conviction review of a case in which the death penalty was imposed, or have served as counsel in a habeas corpus death penalty case in federal court, attended the 12 hours of continuing legal education, capital training within the last 2 years. The remaining subsections here mirror the subsections as above. And again, round out with being familiar with and agreeing to abide by the ABA guidelines. Again, there are alternate procedures in this section B here. So attorneys who do not meet all of the qualifications above can still apply to be on the capital counsel roster as an appellate or post-conviction counsel, and must demonstrate familiarity with the guidelines, agree to abide by them, have experience with appeal and or post-conviction litigation of death penalty cases, and attend an intensive capital training program within 1 year of application to be on the roster. Finally, the procedures for maintaining the capital counsel roster. This is more directed towards the commission and how we'll maintain the roster. I think we have all agreed on the commission as well as the staff that this section needs a little bit of work. And so we're, in as much as we're open to comments on all of the standards as a whole and all of the rules we're proposing, we are looking for some additional comment on this section as well. But basically, we will maintain a roster of the defending attorneys who are competent and eligible to represent capital defendants. They must submit an application. That application must be obtained from the Public Defense Commission. We will try and have the completed application by the end of November for review by our stakeholders and take comment on those. Review and recommendation, there will be a subcommittee basically that will review the applications and make recommendations to the Public Defense Commission for attorneys to be appointed and included on the roster. The composition of that committee is not yet settled, and we're open to comment and suggestions on that as well. Once approved for inclusion on the roster, the term of eligibility is 2 years. No need to reapply within those 2 years as long as the attorney continues to comply with the requirements of the standards, the indigent defense standards, and all applicable professional and ethical responsibility standards. And then any attorney who fails to meet those could be removed from the roster at any time. And then the last section is that the capital counsel roster is available. It will be distributed to counties and administrative district judges at least annually, and it will eventually be on our website. That is the capital counsel qualifications and roster proposed standard. This is sort of a summary here. There must be a defense team, the training and skills that are required, and then we talked about the maintenance of the capital counsel roster. Okay, looks like we got through that in just under an hour. So I'm open to any questions, clarifications that you have for me. You there have on your screen the public hearings that we will be hosting around the state. Our first one is next Wednesday at 4 p.m. Boise time. That will be at the Grove. The commission will be meeting at 2 p.m. that day in the same room, and you're welcome to attend that meeting as well. But we'll move right into the public hearing at the end of the commission meeting. And we'll be hosting on Thursday of next week the public hearing in Caldwell. And then we'll have hearings in Idaho Falls, Lewiston, Pocatello, Coeur d'Alene, and Twin Falls. All of the rest of the hearings besides Boise will be held at 6 p.m. local time. Our hope is to get you in and out in 2 hours. and not go the full, not go longer than that, but we're happy to extend that if we have a lot of participants who like to make comments. These will be more formal hearings than our negotiating meetings, in which we will go through the rules that are proposed, sort of to educate you a little bit on them, and then take comments from individuals one by one, and then we'll close out the hearing. We are still taking comments through the website, through email, by phone, and so if you can't make any of our public hearings, you're still welcome to contact us directly with your comments. The final rules will be created based upon the comments made at public hearings, and we will submit those on November 10th, and those will be final at that time, and we won't be making any changes after that time. So written comments and things like that will be taken up till October 31st. I do notice I have a question. Let me take a look at that. Bradley asks, this is a very good question. I think you all can see the question there. He asks if experienced attorney is defined anywhere, and it is not. Perhaps that's something that the Commission should take under consideration. And all defending attorneys will be required to take continuing legal education under that standard for specialized cases if it's available. And if they're not available, talking to someone who, and I think I would define, if I'm talking about the standard, I would talk about an experienced attorney as one who either regularly handles those specialized types of cases like juvenile or child protection, or someone who has had those 3 hours of CLEs within the prior, I think it was 3 years. And so hopefully that answers your question. But certainly if experienced attorney is not well defined, it's something the Commission could take up and perhaps we need to address. Thank you. I'm going to go ahead and stop the recording now.